Hi, Josh.
Hi, Amanda. What are we talking about today?
I have an interesting potential client this week, and I'm hoping that you can shed some light to our Connecticut viewers on how to answer this question. Client comes in and says, Amanda, I have an OnlyFans page. It has nothing to do with work. My employer knows nothing about it. I don't talk about it at work. But out of the blue, I got called into a meeting by my employer who said, Hey, do you have an OnlyFans page? I answered truthfully and said I did, and an investigation ensued. Can my employer do this? Are my activities outside of work, my recreational activities on my own time outside of work that have nothing to do with work, any of my employer's business? Do I have any recourse? Number one, I didn't know what an OnlyFans page was. I understand now that it is a site that folks can use to create amateur pornography, amongst other things, and get subscriptions from viewers who follow along on their pages and follow along on what they do. So, Josh, my question is, what do I tell this potential client? Does someone have any recourse if their employer is taking action against them based on what they're doing outside of work?
As with so many things in employment law, Amanda, it depends on who you work for and where you work. All right. So if you work for the government, you have a right under the First Amendment to engage in free speech and not to be terminated for certain exercises of free speech, but only if that speech touches on what is called a matter of public concern. There was a case from the US Supreme Court about 20 years ago that involved a police officer who was making pornography wearing a police uniform, though not, I think, his police uniform from the force he was on. And the US Supreme Court said, among other things, making pornography is not a matter of public concern. This is not the kind of speech that is protected from termination for public employees. And so the officer had no claim. So that's the answer for public employees, people who work for a government of any kind, the federal, state, or town level government. For private employees, they typically don't have any First Amendment rights against their employer, but that's not true in Connecticut. In Connecticut, because of our unusual statute codified at 3151Q, private employees have the same First Amendment protections, more or less, as public employees do. But the same analysis applies. Unless the making of pornography touches on a matter of public concern, the employee can still be terminated for it. Remember that if you are an at-will employee, you can be terminated for any reason or no reason at all, so long as it's not an unlawful one. And it's not unlawful to terminate someone for making pornography or having an OnlyFans page, at least in Connecticut. There are some decent arguments that making pornography in certain contexts might be a political statement. And if that's true, then the making itself might touch on a matter of public concern. But we've got the answer from the US Supreme Court that we have, and I think that's the answer that's likely to hold. Now, what I said about Connecticut isn't true in every state. There are states that have what are called lawful off-duty conduct laws. The parameters of them vary slightly from state to state, but the basic idea is that your employer can't fire you for doing something on your own time. That is legal and that has nothing to do with work. So California has a law like this. Colorado has a law like this. North Dakota has a law like this. There may be other states. And likewise, New York, although I don't think it has a lawful off-duty conduct law, does have a law that protects employee recreational activities. So similar, but not exactly the same. So if you are facing this issue in your state, other than Connecticut, where you make amateur pornography in your spare time and has nothing to do with work, and you're concerned you might be fired for it, you might want to talk to an employment lawyer in your state and or just do some Googling and figure out, does my state have a lawful off-duty conduct law such that my making of pornography in my free time that has nothing to do with work might be a protected activity for which I can't be terminated.
So interesting. Gives really good insight into Connecticut employees and employees all over the country about whether or not what they do outside of work impacts what happens to them inside of work. We never know. Maybe Connecticut will catch up with some of these other progressive states. Thank you so much, Josh, and thank you for watching. Take care.